our concurrent session today, and the session is entitled Indigenous-led Justice within a Western Justice Framework. My name is Erin Paquette. I will be one of your two facilitator moderators for this session. I'm joined by my colleague, Ella Weissman from the Center for Innovation in Campus Mental Health. I myself am the Policy Analyst Justice Lead for CMHA Ontario and for the provincial HSJCC. Just a couple of quick housekeeping notes before we get started. It looks like everyone has already done so thanks so much, but just a reminder to keep your microphones muted when you're not speaking, because it helps to keep the background noise to a minimum. If you feel comfortable throughout the presentation, you can put your camera on. It's great to see faces when we're in smaller groups like this one. Just a reminder that, of course, we are aiming to foster respectful discussion throughout our conference. Please remain respectful and consider the impact of your words. All of our sessions are being recorded and they're going to be posted on the conference website for 6 months following today. And we also have some of the PowerPoint resources that are going to be available on the HSJCC website as well. If you want to receive a certificate of attendance for the conference, there is an option to make sure that you're able to do that. So on the conference conference platform, under your individual profile, there is an option to get that certificate, and you just have to click yes on that option. And if there are any incidents that you see throughout the conference today that may have happened, please do report them to the planning committee so that we can address them. So without further ado, I'll turn it over to our speaker, Melanie Garant, from Aboriginal Legal Services. Melanie, it's all you.
Thank you very much. Thank you, sorry. Just a note here, I do have COVID, so I may have to stop to drink water or cough. I'll try to mute myself when I'm coughing, but may not be able to if I'm in share screen. So then if I stumble over words, it's brain fog, sorry. So welcome everybody. I'm glad you made it to this session. Here's an overview of what we'll be looking at in this session. So I always think it's important to talk about how I came up with my perspective. And the fact that I'm Mohawk, Wolf Clan from 6 Nations is something that helps form my perspective. And there's other things I'll be telling you about. I'll talk a bit about Indigenous overrepresentation in the criminal justice system, explain some restorative justice practices, then talk about Indigenous peoples and Gladue courts that are happening across Ontario. Then the Gladue Report process. I am a Gladue Writer with Aboriginal Legal Services. And then I just want to point out the Truth and Reconciliation calls to action for justice. So how did I arrive at my perspective? I decided when I was 17 that I wanted to work with Indigenous people who are in conflict with the law. I worked at the Can-Am Indian Friendship Center for 2 years as a summer student. And at that time, my plan was to go to university and get an undergraduate degree in psychology, which I did, and I got an undergraduate degree in criminology. When it came time to apply to law school, because that's what I thought I was going to be, was a lawyer, I thought maybe I can do this a different way. And I applied for my master's in sociology, and I was accepted. From there, I went to work for the federal government through an Indigenous master's graduate recruitment program. So the theory of it all was we were supposed to spend 2 years and 6-month rotations throughout different departments, which I did. I started off at Indian and Northern Affairs, as it was called back then. Then I went to the Department of Justice and the Aboriginal Justice Strategy. Then I went to the Privy Council for the Métis Federal Interlocutor for Métis and Non-Status Indians. And then I went to the RCMP in the Aboriginal Policing, and I was a policy analyst in all these positions. And I decided to stay at the RCMP because it spoke to me as a place where I could hopefully affect change from within the federal government. I did write on, we had a pillars that the RCMP was supposed to focus on. And one of those pillars were Indigenous communities. So myself and another policy analyst wrote up the framework of how that should operate. And we sent it out across all the RCMP detachments, which we had asked them to decrease a crime of their choosing in their community by a certain %. So I felt that I had achieved what I wanted to do, some change on the ground from within the federal department. So I was happy about that. In 2006, I moved back to Windsor and worked as a healing wellness coordinator and a mental health worker at the Can-Am Indian Friendship Center for 9 years. And then after that, in 2016, I started working for Aboriginal Legal Services. So now I've come full circle because I am working to help Indigenous people who are in conflict with the law. Indigenous overrepresentation in the criminal justice system. Federal penitentiaries in Indigenous populations have increased almost 40% since 2006. Indigenous men represent 30% of all in custody males. In 2018, Indigenous inmates represented 28% of the total federal in custody population, while comprising just 4.3% of the Canadian population. Between 2009 and 2018, the number of Indigenous federally sentenced women increased by 60%. The incarceration rate of Indigenous women continues to climb. It's at 12.5 times higher at this point than that of non-Indigenous women. In 2018, 40% of incarcerated women in Canada were of Indigenous ancestry. And in 2016-17, Aboriginal female youth accounted for 60% of female admissions to correctional services, while Aboriginal male youth made up 47% of male youth admissions. I will be switching back between Indigenous and Aboriginal. I prefer Indigenous, but some of the research I was doing had embedded in it the word Aboriginal. So Indigenous peoples and the court. Go back one. Indigenous peoples are largely economically impoverished and cannot afford to hire their own counsel, so they are less likely to take a plea bargain or to benefit from a negotiated plea, and they're often underrepresented or unrepresented in court, and they're more likely to make a guilty plea. Aboriginal people are more likely than non-Aboriginal people to leave the legal process without understanding and therefore without respecting what has occurred to them and why, because they don't have that guidance. A study in 1991 by Letourneau et al. Claimed that the impact of the justice system on Indigenous persons is most apparent at the sentencing stage. Many studies over many years have noted the high rate of incarceration of Indigenous offenders. Even more disturbing is that the Indigenous representation in prison populations has moved upwards over time, a situation which is completely unacceptable in a society that prides itself on being free and democratic. So why the need for restorative justice? This is a word you've probably heard a lot, and actually I really enjoyed Mick Coons's, sorry if I pronounced his last name wrong, his session on the advantages of integrating creative practices in restorative justice. I found that a very enlightening conversation that he had. So Turpel in 94 claimed that the adversarial system, the criminal code, the prison system of punishment, the psychological model of rehabilitation based on confession and repentance, and the paternalism of parole are all foreign practices to traditional Indigenous societies, even though Indigenous people are well acquainted with them in practice. Even though in today's day and age, Indigenous people are familiar with how the justice system works, that does not mean that they have any control over the negative impact of such a system on their lives. Turpel in 93 claimed that one of the biggest difficulties with the criminal justice system for Indigenous people is the fact that it is oriented toward punishment of the offender in the interest of society by imposing a term of imprisonment, fines, and less often forms of restitution and community service. The two cornerstones of punishment, imprisonment, and fines are both alien to Indigenous peoples, traditionally. The goal for Indigenous communities were to, in the past, where after an incident of harm had been done against a person or possession, was to resolve the immediate dispute through healing wounds, restoring social harmony, and maintaining a balance among all people in the community. Harmony, balance, and community welfare cannot be satisfied when an individual is imprisoned or taken out of the community. In very rare cases, Indigenous persons may have been banished from the community in the past, but imprisonment might sometimes be the offender's only avenue for healing restoration. Also, when the offender is removed, it may not be possible to restore the victim and the victim's family or clan to right the wrong that has been done. If the offender is paying a debt to society through a prison term, what about the repair of the debt to the victim and others in the community? Then there's the principle of non-interference. Sinclair, in a study in 1994, said the differences between Indigenous and non-Indigenous cultures. He found that the primary meaning of justice in Indigenous society would be that of restoring peace and equilibrium to the community through the reconciling of the accused with his or her own conscience and with the individual or family that was wronged. Indigenous cultures approach problems of deviance and nonconformity in a non-judgmental manner with strong preferences for non-interference, reconciliation, restitution. The principle of non-interference is consistent with the importance Indigenous peoples place on the autonomy and freedom of the individual and the avoidance of relationship-destroying confrontation. So what else can be done? I'm just going to go over some restorative justice processes here, and it may be old news to you, maybe new for some. So there's diversion. Diversion is when you're offered a chance to do something like community service or counseling to have your charge withdrawn, which means it's dropped permanently, or stayed, where it's put on hold for a year. Sometimes the Crown can see that a case does not need to be dealt with through guilty pleas or a trial. Diversion circles in a community can be where minor offenses are not even brought before the courts, but dealt with directly by the community members. Then there's mediation and healing circles. Mediation and healing circles are different for every community. You have to remember that there's not a pan-Aboriginal approach to Indigenous justice. It's up to the communities to figure out how justice works for them. When I was coordinating the sentencing circle process in Ottawa, we would ask the harm doer to attend 4 healing circles prior to their sentencing circle. We also offered healing circles to those who had been harmed. The circle would be an elder and 2 committee members, as well as the person being harmed or who had harmed. This is a chance to work on healing objectives, addressing the 4 aspects of self, which are physical, mental, spiritual, and emotional. You may have seen depictions of medicine wheels with the red, white, black, and yellow. That's the medicine wheel, and you have those 4 aspects of self. There's actually a week-long course teachings on the medicine wheel, so it can be quite complex at times. During the process, the elder committee members would get to know the person and be able to suggest programming and counseling and whatever may contribute to their healing. Sentencing circles is something I could talk about for hours because that's what I wrote my thesis on. I actually put a link to my thesis in my profile. And I conducted a study of sentencing circle practices across Canada, looking at court statements and judgments. It is outdated, though. I mean, I wrote my thesis in 2001, but there's still some stuff to learn from that. Sentencing circles in the past were community-driven initiatives, but with the rise of Indigenous people's courts in Ontario, they are being used in place of sentencing hearings, now more than ever before. The judge, Crown, and defense take part in a sentencing circle. People literally sit in a circle for the process. The offender is there. Sometimes the victim is there. An elder, family, support people, and the community are also there. An eagle feather is usually passed around the circle, giving anyone a chance to speak without being interrupted. An eagle feather, in our culture, it's the bird that flies the highest and closest to Creator. So if you have that eagle feather, what you're saying has to come from the heart. It has to be truth, and so that the Creator will see you. An eagle feather is usually, every person has a say as to what form they think the sentencing should be. Probation, conditional discharge, suspended sentence, community service, and more. People can get creative with their suggestions, such as attendance at a land-based healing camp, talking to an elder for guidance going forward, taking part in traditional ceremonies, community's volunteer service work, and the list goes on. The original proponent of sentencing circles, former Yukon Judge Barry Stewart, suggested that each circle should be unique to the community in which it is undertaken. However, the circle can be broadly defined as one that may only take place in cases which the offender has accepted full responsibility for their actions. In most cases, offenders must accept full responsibility for their crimes and be willing to change in order to be eligible for a sentencing circle. Judges often outline acceptable ranges of sentencing for community members to work within. Even so, most judges would hold sentencing circles are willing to depart from the usual range of sentencing. Sentencing circles involve a voluntary, though limited, delegation of judicial power to the community members, and sentencing circles may or may not include a traditional or healing component. Even when community members have in place substantive guidelines for how the circle should proceed, I found that judges can supplement and/or override these guidelines with the establishment of specific court procedures. Ross Gordon Green found at the conclusion of the study on sentencing alternatives in Indigenous communities that although the Indigenous practices, such as sentencing circles formed an integral part of the sentencing process, their inclusion appeared to be more of an adaptation to conventional court protocol than an adoption of traditional Indigenous dispute resolution practices. Conventional Canadian adjudication practices were retained, with the judge controlling the final sentencing outcome. Despite the continued prominence of judges and lawyers, these community sentencing approaches nevertheless demonstrated the flexibility of Canadian criminal law in allowing local participation and in recognizing traditional Indigenous practices during sentencing. The input of victims to ensure that offenders remain acutely aware of the devastating pain and suffering these crimes have caused. The plight of victims can be instrumental in prompting offenders to pursue rehabilitation. The role of victims, then, according to one judge, is to help offenders on a rehabilitative path. Communities who hold sentencing circles should have both circle support groups and victim support groups, regardless of the offense. In order for victims to fully participate in sentencing circles, they need to feel secure that they will not be re-victimized and that their concerns will be addressed fairly. Counseling for both the offender and the victim should take place before and after sentencing circles. In order to help heal members of the community members must do more than provide input at a sentencing circle. They can counsel offenders and allowing them access to treatment and healing ceremonies. The members of the community the participation of offenders in such initiatives will also show judges and other members of the community that offenders are willing to change and that they will be committed to a rehabilitative plan. Sentencing circles are one way that communities can start the healing process for offenders, victims, and communities as a whole. Chartrand in 1995 argued that Indigenous communities must begin a process of restoration to heal themselves. That restoration process begins with respect. To regain respect, members of Indigenous communities must have control over their lives, including control over their social order systems. Circle sentencing can be seen as an important building block in the process of restoring Aboriginal community respect and healing. In the circle sentencing process, this restoration can be achieved by allowing the community to have final control over the decision-making that determines the appropriate disposition for an offender. Another factor that will impact the development of sentencing circles is the resources available for holding of such circles and for helping both offenders and victims. Green stated that it's unrealistic to expect that a few hours in a sentencing circle will permanently alter historic patterns of offending and imbalances of power. Clearly, sentencing circles can be catalysts to start the significant changes in behavior on the part of offenders. Any chance of achieving this goal, however, depends on the availability and success of locally accessible resources, including support, treatment, and counseling for victims and offenders, and in the cases involving abuse, close supervision of offenders and protection of victims. So what else can be done? Just play a short video for you here.
What is restorative justice? Restorative justice is an alternative model to the criminal justice system and focuses on repairing the harm between the person who received the harm and the person who caused the harm through a circle process.
Healing circles have always been a part of our Haudenosaunee culture. We are now ready to revitalize our original way of healing for our people all across Turtle Island. And I think that's the beauty of restorative justice too, is that within that circle process, these two people are going to talk about how that harm can be repaired between each other. That's without the criminal justice system, that's without labels, that's without blame, that we're focusing on connecting behaviors and that we're focusing on healing that harm, the known victimization that happens within our community of thinking that they're always going to be that victim, or thinking that that person is always going to be an offender for the rest of their life. If that was the case, then we wouldn't have people like Taradaho, or we wouldn't have had people like Jigonsose that were huge people in our original teachings that had that transformation within themselves. But we had to have consistency, and we had to have compassion for them, and we had to show them love, that their community was behind them, and that no matter what, we are going to support them to bring them back to who they originally were.
Really being able to heal and move forward in a good way, and as we say, with a good mind. That's really the other focus of restorative justice, is to heal. When we heal one person, that person may be able to heal another person, and it's exponential from there. And that's how we're going to build a strong, safe community, is by all healing and working together. So when we have strong people, we have strong nations, we have strong clans, we have strong communities.
Okay. So what's guiding this Gladue thing you may have been hearing about? Some of you may totally understand the Gladue process and the reasonings for it. Some may not, so I'm just going to give some information. There's a section in the Canadian Criminal Code 718.2e. It reads, "A court that imposes a sentence shall also take into consideration the following principles. All available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to victims or the community should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders." And this section was explained when the Supreme Court of Canada gave its decision in R versus Gladue. Among Canadian jurisdictions, Ontario led the way in creating Gladue courts within the provincial court system. The first Gladue court opened in 2001 at the old City Hall courthouse to hear criminal matters, followed by 2 more Toronto courts by 2006. There are 19 Indigenous Peoples Courts / Gladue courts operating in Ontario right now. And actually, I'm pleased to tell you that in Windsor, we do not have an Indigenous Peoples Court, but we do have a committee that's working right now to get one established. It's quite a process, doesn't happen overnight, but we are working towards that goal. In addition to the colonial courts listed above, a court in Akwesasne, Ontario, works with an independent Indigenous legal system pursuant to the Akwesasne Self-Government Agreement signed in 2012. The legal system replaces the Ontario, Quebec, and American systems which overlap in their territory. So why is there a need for a use of Indigenous peoples' Gladue courts in Ontario? They came into being as a result of Section 18.2e and the Gladue case. Indigenous peoples' courts were also known as Gladue Court, is a specialized court that handles the cases of Indigenous persons who've been charged with a criminal offense. Indigenous peoples' courts are Canadian courts that apply Canadian law, but also include Indigenous cultural practices and Indigenous concepts of justice, such as restorative justice. These specialized courts specifically focus on sentencing and in some locations also bail and case management. They do not handle trials or preliminary hearings. Indigenous peoples' courts are staffed with legal personnel that have specialized training the application of Gladue at bail and sentencing for Indigenous accused. Efforts are made to adopt a more restorative approach and involvement of Indigenous service providers. Elders, knowledge keepers are an integral part of the process. The Ontario Judiciary, in consultation with collaboration with the provincial and federal crown, as well as local Indigenous communities and organizations, have established the Indigenous Peoples Courts around the province. Indigenous or Aboriginal court workers are assigned quite often to work with each Indigenous accused. Sometimes they might include helping to organize a Gladue Report, which I'll speak about soon, which is a type of pre-sentencing or bail hearing report that the court can request when considering sentencing for or bail for an Indigenous offender. The Gladue Report attempts to give a holistic account of the offender's personal history and the systemic factors affecting Indigenous persons who appear before the court. So I have a bit longer video. This is Jonathan Rudin. He's the Director of Special Projects at Aboriginal Legal Services. Right, go on. No, that was right. Okay.
Some people refer to the Gladue sentencing principles as a get-out-of-jail-free card or a race discount. This is simply not true.
Hi, I'm Jonathan Rudin. I'm a lawyer and the Program Director at Aboriginal Legal Services of Toronto, and I appeared at the Supreme Court of Canada in the Ipeely case. Section 718.2e of the Criminal Code was enacted as part of the general sentencing provisions in Section 718 in 1996. And it's probably fair to say that no one was really quite sure what Section 718.2e meant until the Supreme Court of Canada came up with its decision in Gladue in 1999. And in Gladue, the Supreme Court of Canada said that the overrepresentation of Aboriginal people was a crisis in the Canadian criminal justice system, and that it was important for judges to do what they could to remedy that problem. And that required judges to look to the circumstances of Aboriginal people, to understand why it is that Aboriginal people come before the courts, to understand some of the historic issues that have plagued Aboriginal nations and peoples and have led to overrepresentation in the criminal justice system. Gladue said that the sentencing of Aboriginal people had to be done differently. And in some places, and at some times, and in some cases, that was true. But it's also fair to say that between 1999 and 2012, there continued to be a lot of confusion in the courts about what Gladue actually said. And so in 2012, the Supreme Court of Canada released another decision called Ipeely. And this is a case that I was fortunate enough to be at the Supreme Court for and arguing for Aboriginal Legal Services. And in Ipeely, the Supreme Court of Canada said, you know, all that stuff we said in Gladue, we meant it. And that was an important thing for people to hear because it started to clear up some of the confusion about the way in which Gladue should be interpreted. At the same time, the court said that the concerns about overrepresentation that they had discussed in Gladue were still with us. In fact, overrepresentation of Aboriginal people in prisons has got worse since the Gladue decision. Right now, 1 in 4 inmates in Canadian jails are Aboriginal, and the percentages are higher for Aboriginal women, and higher still for Aboriginal youth, and highest still for Aboriginal girls. What the court said in Ipeely was that we need to be upfront about the fact that colonialism has had a real impact on Aboriginal people, and courts should not be shy to address those sorts of issues. They also said, to clear up confusion, that Gladue applies in all cases where Aboriginal people are sentenced, regardless of the seriousness of the offence. And the court also, for the first time, referred to Gladue reports as examples of things that can actually help judges do their job better.
Wait a minute. I have friends with family problems, substance abuse problems. What makes natives different?
Section 718.2e of the Criminal Code, which is the section we're going to be talking about, applies to everyone. The section says judges should look to alternatives to imprisonment for all offenders. And then it goes on to say, with particular attention to the circumstances of Aboriginal offenders. But certainly judges all the time consider all the circumstances of everyone.
I don't get it. Why can't the natives just get over it?
The impact of government practices, such as residential school, the mass adoption of Aboriginal children, we're really just only now coming to grips with understanding what the impact that those policies have had and continue to have on Aboriginal communities. So it's not a question of getting over something. It's really a question of the justice system recognizing what has been done to Aboriginal people.
Hey, I'm Aboriginal. Does the Gladue principle mean I won't be convicted of my crime?
The Gladue principles primarily apply at sentencing. They also can apply at bail. Where they don't apply is during the trial. So the way in which we determine whether someone is guilty or innocent is the same for everyone. So as a result, Gladue has no impact on whether or not you're guilty.
I haven't lived in a reserve for 10 years. Does the Gladue principle still apply to me?
It's really important to note that the Gladue principles apply to all Aboriginal people. It's Indian, status, non-status, Métis, Inuit. Whether you've lived on reserve or have never lived on reserve, whether someone was adopted at 6 months old, none of that matters. If you are an Aboriginal person, the Gladue considerations must be applied in your case.
Why are Aboriginal people getting special treatment in the courts?
The Supreme Court of Canada has repeatedly found that the criminal justice system, as it's currently constructed, discriminates against Aboriginal people. Section 718.2e doesn't provide special treatment for Aboriginal people. It tries to get Aboriginal people the same treatment that everyone else gets in the justice system. It's true that the experience of most people before the courts is one of difficulty. Most people who come before the courts come from poverty. There's often family dislocation. But what makes the circumstances of Aboriginal people unique, and what the courts have commented on repeatedly, is that the reasons that Aboriginal people face these difficulties is a result of colonialism. And it's this reality that makes it so important for the courts to understand the history of both the Aboriginal offender and the systemic issues surrounding his or her community.
Why doesn't sending Aboriginal people to jail seem to work?
Many studies have shown, and in fact the Supreme Court of Canada itself has noted, that jail doesn't seem to work for Aboriginal people. And one of the reasons is because Aboriginal people face racism in jail. And it's a racism that continues to this day. And so the reality is that while jail may not work for anyone, it particularly doesn't work for Aboriginal people.
Know your rights. If you, a family member, or one of your friends is in conflict with the law, then you need to understand and know the Gladue principles. Restorative justice is possible.
Okay, so you may be in a position, whether you're a lawyer, work for a law firm. Oh, sorry, something's still going. There we go. You may be working with Indigenous people who've been convicted of a crime and they've pled or been found guilty, and you will be able to direct them to the Gladue process. So how to request the Gladue report? You can find the report request form on the Aboriginal Legal website under Gladue Report requests. Gladue request form cannot be given directly to a Gladue writer. I cannot take it directly and start working on the case. It must be faxed or emailed to my head office. And Kim White Duck, our coordinator, will vet all the requests, get in touch with the clients, make sure I can get in touch with them if it's assigned to me. And then she sends it off to my manager for approval, and then my manager will assign a case to me. There are 11 regions in Ontario where ALS Gladue writers are present. So what type of information does the judge need? They need background information. If they're considering people's unique life circumstances, they need to know what those unique life circumstances are. So, for example, looking at families, whether something happened to them or their families, did they or a family member attend residential school? Were they adopted or in the child welfare system? Did they grow up in a home where there's abuse or addictions? Do they have addictions, mental health, or fetal alcohol spectrum disorder? And information about the community, and usually much more. What type of information does the judge need to consider non-jail options? The judge needs to be told about sentencing options instead of jail, and all non-jail options can be considered under Gladue, even if they're not Indigenous programs. That's kind of a misconception out there that Indigenous people have to go to Indigenous programming. No, they can go to mainstream. If that's what they want, that's fine. And the Gladue writer says, yeah, that's good for you. That's one of the recommendations. If there are substance abuse programs or other types of healing programs, the judge will need to know where these programs are and if the person can get in. Usually there's wait lists. The judge wants to know how long the wait list is and what the next startup cycles are for the programs. The judge may also want to know about any suitable programs or activities of the person's community on or off reserve. Again, the judge will need to know if the person can get in. So there's different health branches on reserve that deliver a number of programs. So if a person lives on reserve, they're more than welcome to attend those types of programs. If somebody lives off reserve, most likely they'll be going to a friendship center to obtain programming. And when does Gladue apply? Well, Jonathan already spoke about that, so I don't have to repeat it. He didn't say that Gladue applies to parole hearings when somebody's in jail. So what's the role of the Gladue writer? What do I do daily? I'll receive the assignment from head office and contact the client as soon as possible. The first interview, I learn about their Indigenous ancestry. All ancestry has to be verified as per agency policies. Sometimes people live on a reserve and have a status card, so ancestral verification is completed by contacting the band office or on the reserve to ask if the individual is a registered member. Sometimes people are disconnected from culture or community, either because they're adopted or in the child welfare system. Other times it may be that family members do not want to talk about their ancestry. Most times I found that seniors who went to residential school do not want to talk about their past, and I don't blame them. If a person does not know much about their ancestry, I'll ask them for as many ancestors' names that they can provide. I must conduct an ancestral research. The tools I use are Ancestry Canada, databases such as Library and Archives Canada, Just Archives Canada, Our Ontario, and I look at census data over the years. and I search for Indigenous identifiers in the various historic documents. If I find some Indigenous identifiers and it's only a few generations back, my manager will ask me to proceed with the Gladue Report most times. Otherwise, my manager will have to make a decision as to whether or not she needs to send a no Gladue Report letter to the court, outlining the steps I took to try to verify the person's Indigenous ancestry. And sometimes it takes me days to find something or find nothing. I just keep digging and digging as much as I can for the person. Once ancestry is verified, the interview process will continue. So I'll interview people who are familiar with my client's life circumstances, such as family members, Native inmate liaison officers, social workers, counselors, program facilitators, employers, and the list goes on. Whoever can speak to this person's life and what they've been through. I'll roll up all the interviews and write the Gladue Report. On consultation with the client, I will provide recommendations for sentencing. So I can't just say this person should go to X, Y, Z, and that's going to help them. If a person doesn't want to go to X, Y, and Z, I'm setting them up for failure. So it's always a collaboration between me and the client, figuring out what programs and other things are good for them to help their rehabilitation. Once the report is edited, I will send it off to the judge, defense counsel, and Crown attorney prior to sentencing. The Truth and Reconciliation Commission calls to action in the justice sector. So they want to call on eliminating the overrepresentation of Aboriginal people in custody over the next decade. And this has to be monitored and evaluated. Providing sufficient stable funding to implement and evaluate community sanctions that will provide realistic alternatives to imprisonment for Aboriginal offenders and respond to the underlying causes of offending. There's a call to allow judges, upon giving reasons, to depart from mandatory minimums and restrictions on the use of conditional sentences. The government's call, we will call upon the federal, provincial, territorial, and Aboriginal governments to commit to eliminating the overrepresentation of Aboriginal youth in custody over the next decade. And then there's also asking governments to commit to the recognition and implementation of Aboriginal justice systems in a manner consistent with the treaty and Aboriginal rights of Aboriginal peoples, the Constitution Act of 1982, and the United Nations Declaration on the Rights of Indigenous Peoples, which was endorsed by Canada in November 2012. So there we go. I'll just, there. Stop sharing.
Thank you so much, Melanie, for such a thorough overview of Gladue principles and of the work that you do that is obviously crucial to the individuals you're helping to serve, but to Indigenous communities across Ontario. So thank you for that work that you do.
You're welcome.
And thank you so much for this presentation. I'm pretty familiar with Gladue principles, and there were still things in here that I was able to learn and to take into my work at CMHA, so thank you for that as well. So we do have some time for questions with Melanie, which is fantastic. So if you have any questions for Melanie, you can do it one of two ways. Given that we're, I believe, a relatively smaller group, you can pop on to ask your question verbally, or you can put it in the chat. And if you can just put the word question in front of it so that we can filter, that would be very, very helpful. Maybe I can start with a question to get things sort of going. So Melanie, during our keynote panel this morning, we were talking about youth in transition and youth in custody. And I was wondering if you could share a little bit more information about Indigenous youth who are coming into contact with the justice system. What has been your experience with that? What are you seeing with some of your clients?
Okay. Well, actually, I've only had one youth client in the 7 years that I've been working. So, but in general, I mean, there's some petty crimes. There's some major crimes that people are committing. And I've found that a lot of the times with my younger clients, I can refer to them in this, is that they just don't have support in their family, in their community. All of my clients, every single one has a childhood trauma. So that really impacts a person in their decision making in their later life. So I think that's part of it. Part of it is that there is no restorative practices in some communities. So if the youth commit an offense and they go directly to the courts, then they're not being helped as far as rehabilitation at the beginning. So that's why diversions are the best thing to work with Indigenous youth, because why have them have a record if they can do some community service or go to counseling or something like that?
A more holistic approach is what.
Yep.
Yeah. We do have a question that's popped into the chat. The question is, we're aware that Indigenous people are underrepresented in the forensic mental health system. So people who are ultimately found not fit for trial or not criminally responsible due to NCR is the acronym we're looking at. Do Gladue principles or reports take fitness or criminal responsibility into account? And then the second part of that question was if there is a pathway to forensic mental health services that is in place for Indigenous individuals coming into contact with the justice system.
Okay. Yeah, let me see here. How should I frame this? Gladue principles do take that into effect. I'm seeing people at the pre-sentencing stage. So at the beginning end, like where they're arrested and such, and the Gladue doesn't cover that other than bail. But if somebody needs a mental health assessment, we write the court and suggest that they need mental health assessment before they can proceed with the Gladue Report process, because we want to make sure that they're not doing something that they don't even know. They don't know what they're saying, they don't know what they're doing, whatever their mental state is. We want to make sure they're in a good place. As far as any mental health services in place, there's reserves again that have the health center, that have mental wellness counselors. If your status, you get, I think it's still 10 sessions with a psychologist paid for by non-insured health benefits. So that's always important to let our clients know that they can access that.
Thanks, Melanie. Another question was if there's a new law that requires mandatory charging in relation to situations of domestic violence, and this person is asking if there might be some sort of connection with an increase in Indigenous women being charged with those types of offenses.
Right. I would think so. I haven't read any findings on that or studies, but unfortunately, there is abuses that happen in domestic relationships for every community, every culture. But because of the impacts of colonialism and how it leads people to lead their life, there's going to be abuses. So yes, of course, if the woman has abused their partner, then they will be charged as well.
And the next question that we're going to jump over to is whether or not Gladue interfaces at all with the NIHB program to divert people from the court system.
Right. Well, that's what I was talking about, the 10
non-insured
sessions. Yeah. Non-insured health benefits. Yeah. So there is the sessions that you can have with a psychologist, which I think if it's in the beginning stages of the process, the lawyer can make a request that their matter be held over until they're able to attend so many counseling sessions or whatever it is. It's probably over the phone or Zoom now. It wouldn't be in person so much, but you can see in-person psychologists. And I think registered social workers as well is covered under that policy.
Thanks, Melanie. I'm not seeing any other questions in the chat here. Ella, if you'd like to ask any questions, or I have another one that I can ask Melanie if
Go for it, Erin.
Okay. So Melanie, you spoke towards the beginning about the distinct sort of the way that Indigenous communities, obviously this varies community by community, but how they understand justice as a different concept from the way that it is envisioned in the Canadian court system. And I distinctly remember the moment as a graduate student when someone explained to me that in Canada you commit a crime against the state and not necessarily against an individual person, and how that led to an adjustment in my thinking as a non-legal professional about what sort of justice looks like in Canada. And I was wondering if you could elaborate a little bit more on that sort of understanding within Indigenous cultures about what justice looks like. So you spoke to it this earlier on, but I just wondered if you could maybe speak a little bit more about that.
Yeah, no problem. Well, like you said, and I've said, that it differs between communities. We're not like one cohesive organism of Indigenous across Canada.
Yeah, of course.
So it goes community by community, but I did refer to some studies that I had read for my master's thesis, and they really delved into Indigenous justice. And actually, as an aside, my thesis advisor, I wanted my title to be Aboriginal Justice within a Western Justice Framework. He said, you don't know what Aboriginal justice is. You know an idea of Aboriginal justice. So that's why I had to reframe my whole thesis based on that one comment. So the idea of Aboriginal justice is cohesiveness, harmony, balance. Balance is very big in Indigenous culture worldview. Working with both people, the harm doer and the harmed, and the community, like kind of restoring the where people should be at in the community after this offense has been committed. I did say that there were some communities that would go for banishment. So in a way, jail isn't completely foreign, but banishment is where a person basically has to go to an area of land by themselves for a certain amount of time, and they're given some supplies, and that's what they do. Basically, they have to think about what they did for quite a while. And it was always there's also an aspect of where a harm doer harms someone, they had to repay a debt to them and their clan. So if somebody harmed me, they would have to also repay a debt to the Wolf clan because you've harmed one person of the Wolf clan. So it's cohesive like that. Yeah.
Thank you so much. I'm actually not seeing any further questions in the chat, so maybe I'll open it up. If anyone would like to verbally ask their question, here is your moment. And if that's not the case, maybe we can end just a little bit early, and we'll give people a little bit of time back. Okay, I think that's what we're going to go ahead and do. So we'll give people a little bit of time back in their day, but just a reminder to everyone, there is a networking session that is beginning at 12:30 on the platform, so you're more than welcome to attend that. But otherwise, we will see you back after lunch. And thank you so very much to Melanie Garant from Aboriginal Legal Services for your insight, and thanks also to my co-facilitator, Ella Weissman.
Thank you. And thank you for your facilitation. That was quite helpful when I was trying to get the technology right in the beginning.
Technology is the bane of everybody's existence, I think. Thanks so much, everyone. Have a great day.
Have a good day.